my pleasure to introduce Drew Harding today. Drew and I actually went to law school together here at TU. He graduated a year before me in 2004. Since then, he has served as Associate General Counsel for Unit Corporation. While he was here at TU, he served as the Editor-in-Chief of the Energy Law Journal and President of the Christian Legal Society. Another little interesting tidbit, Drew played football for the Baylor Bears. We won't hold that against him. There was a little beam of pride this afternoon whenever he told me that they're currently ranked number 2. So, today Drew is going to be speaking on managing corporate liability in a highly litigious and regulated environment. And without further ado, I'm going to hand the podium over to Drew.
Thanks, Christy. Appreciate it. Thank you guys very much. I appreciate it. You guys did steal our offensive coordinator, so there's no resentment there, but there is now a nice connection between Baylor and TU, which makes me very happy because I love both places very much. Unit Corporation is a diversified oil and gas company. We have an upstream segment, a midstream segment, and a contract drilling segment. For an independent, it's very unusual for us to have this variety of operations. Typically, most companies you see just the upstream, just a service piece. A lot of times now, though, you're seeing a coupling of the upstream and the midstream pieces as well. So it's very unusual to get all three, and so I get to see a lot of different things. And when I was asked to speak, typically when I speak, I'm speaking on a specific topic. And when they invited me to come and speak at this series, I asked, what do you want me to talk on? And they said, well, you can talk on whatever you want. And I was very excited about that initially until I realized I really don't have anything interesting to say. And started racking my brain on what can I talk about for an hour that is going to come remotely close to holding anybody's attention. And so that process took a long time. And I ultimately decided that I was probably best served, and probably interest people the most, especially if we have students in a room, just talking a little bit about what I experience on a day-to-day basis, what my job entails, and specifically what I'm going to hone in on are the challenges we face and what I consider an extremely highly litigious and regulated environment. And we are actually seeing things just exponentially grow in these worlds. And it's creating a lot of challenges for corporations and specifically for in-house counsel. And so I'm going to do a little bit of a survey and kind of go over some of the things that provide really big challenges to us and to me personally. This is in no way exhaustive of what we deal with, but kind of get some highlights and some things that may be of interest to you. Quick housekeeping before I go any further. My opinions today are mine only. They don't represent Unit Corporation. So in other words, don't buy or sell unit stock based on anything I say here today. The first thing I'm going to cover is the area of personal injury, which doesn't sound very sexy for an in-house lawyer to talk about, but it's a huge part of my job. We don't handle the actual litigation. We farm that out to firms, but we have to oversee it all, and we're very, very proactive in our litigation. So we don't just hand it out to a firm and say, fix this problem for us, get us a good result. We're involved in every step of the way, from discovery to mediation to trial if it goes that far. So we're very proactive, and so this takes up a lot of my time. In the civil area of personal injury, as I mentioned, we have a contract drilling company. Contract drilling is a high-risk business, and we have lots of injuries, and unfortunately those injuries tend to be of the more severe nature. So this is not your typical Walmart slip and fall type personal injury world that we're living in. The world we live in, we're dealing with amputations, we're dealing, unfortunately, with fatalities from time to time. So we're dealing with some very, very serious injuries, and so the exposure is extremely high. Drilling contracts are set up on what's called referred to as a knock-for-knock basis with respect to personal injury. And so what happens is the drilling contractor says to the operator who owns the well, who had hired us to drill the well for them, we're going to take care of our guys. So if any of our guys or our subcontractors, if they get hurt and sue you, we're going to defend and indemnify you guys. And then vice versa, it flows back the other way, where if any of their guys or subs, and they have very few employees out there, usually a consultant, but they do have subs out there quite a bit, and so that's really the main party that we worry about in that standpoint. If they sue us, then the operator has to identify and defend us. And so that's the contractual risk, very basically stated, how that world works. And so because of the amount of injuries that we encounter while drilling a well, we deal with this risk relationship quite a bit, and we defend and identify in a lot of personal injury claims. So even though our employee, generally speaking, can't sue us because of workers' comp immunity, they oftentimes will sue the operator. And this is a very difficult situation because, like I said, we are becoming an increasingly more litigious society. And most of the time, the operator has nothing to do with the injury that occurred. Okay? It's our guys, it's our equipment, we're the ones out there performing the work, and the operator is overseeing from a very broad level. They're not out there typically giving a lot of directions, they're not micromanaging anything like that, but nonetheless, plaintiffs' lawyers will sue the operator because they know they can't sue the employer. And so when they sue the operator, we have to come in, now we have to defend that claim, and we have to identify the operator. And so we deal with a lot of personal injury from that standpoint. And so managing that can be tricky, especially when you have very, very serious injuries. Wrongful death cases, unfortunately, I've had to experience a fair share of those over my time at unit. And those have to be managed very, very carefully. And so there's a lot of time spent at the rig, investigating the claim, interviewing the employees. So the investigation piece of it is critical in order to determine what type of exposure do we have. And oftentimes our goal is to determine what type of exposure the operator may have if we're in a position of identifying them. Most of these cases settle, no big surprise. I would say 95% of personal injury cases ultimately get settled. Most of the time at mediation. Mediation is an extremely frustrating process. It's a necessary evil. It's a huge time drain. You go in there, oftentimes they'll take up your entire day, and you start out with these crazy numbers. I'll pay you $10. I want $10 million. And then you have to work your way to some type of hopefully middle ground where you can compromise. It actually a lot of times is effective at the end of the day. It's just an extremely painful process to go through. But a few of them do go to trial or arbitration. Arbitration, we found, is not quite as great of a deal as a lot of people make it out to be. It's supposed to be much cleaner, faster, more efficient, less invasive. We haven't really found that to be the case. We found a lot of arbitrations actually take just as long, if not longer at times, as a civil case. The discovery situation is very frustrating because typically arbitrators aren't going to get involved in those disputes and make any type of ruling. So really it's kind of the wild, wild west with respect to discovery and admissibility of evidence. Everything comes in. And then the biggest thing that's really concerned with arbitration that we found that's really turned us off is it's really depending on the system you're using, it's the luck of the draw. You get a bad arbitrator, you get, for instance, a bleeding heart arbitrator that's going to make this injured employee rich no matter what, then there's nothing you can do about it. There's no appeal rights, it's binding. The options for appeal are extremely limited. It has to be extreme abuse of the law. So that virtually never happens. And so it's really a crapshoot. And so the arbitrations we've done, we're about 50-50, honestly. And the results that we've had some really good results, and we've had some really bad results that we thought were completely contrary to law, that again, there's nothing you can do about it. So arbitration, we're not quite as high on as we used to be. It really all depends on having a good arbitrator panel that you're choosing from. And that's a whole other deal. The other area of personal injury risk that we deal with quite a bit is workers' comp. Now, if personal injury does not sound sexy to you, workers' comp is even less so. And when I graduated law school, I never would have thought I would have anything to do with workers' comp. Unfortunately, it's become a fairly large part of my life, just because of how much money it costs us, especially in Oklahoma. And matter of fact, Oklahoma is so bad. Oklahoma for the past several years has ranked in the worst two or three states in the country as far as workers' comp goes. And it's been run by the plaintiffs' bar for decades. And prior to 2013, we had a judicial workers' comp system, and so there were workers' comp judges, and it was very much treated like a civil lawsuit. And unfortunately, there was really no check and balance or accountability in place, and so the plaintiffs' bar was making a ton of money off of workers' comp. And so in 2013, Unit Corporation was one of the main movers of this, and a couple other companies like Hobby Lobby. We had formed a coalition back in, I believe, around 2011. And the coalition was based off of a common experience that we had in Texas. In Texas, you can actually, by statute, you can elect not to carry workers' comp coverage. And you don't have to do anything. So you can decide the Texas Labor Commission no, file a form, we're not carrying comp, that's it. And you can just do whatever you want, which sounds great, except the rub is, in exchange for that, you can now have no immunity. You can get sued in district court for ordinary negligence, which is a concept that you do not see in typical workers' comp statutes. And so a product had developed over years, an ERISA-based health benefit plan that operated very similar to a private group plan that you'd see in your place of employment. And it allowed employers to manage, self-administer the work comp claims. And what we found out is that you can have great savings if you can get away from the bureaucracy of judges and lawyers. You can actually get guys treated quickly. You can require them to show up to appointments. You think that's not an issue. Getting injured employees to actually go get treated and show up to appointments, and that's the only thing to do, is actually a huge problem. So you can cut out so much of the bureaucracy and the problems and obstacles, and you can get them better treatment and get them back to work much faster, which is a good result all the way around, instead of having claims go 3-5 years. And so Unit, on the drilling side, we entered into non-subscription back in 2006, and several other companies had as well, and we had huge savings. And so this was a common bond that brought us together. We got together and said, okay, what can we do with the current system so that in Oklahoma, so that we're not in this bad place where our premiums are so high, and we can't control the claim, we can't get the guy to go to appointments, we can't close out the claim. And so we got together as a group and we started working, and I won't go through all the details of it, but the final product we came up with was Senate Bill 1062 in 2013, which we ran, which was an overhaul of the entire workers' comp system. We got rid of the judicial system, and we put in place an administrative system, which every other state in the country has, which is much cleaner, much more efficient, much less burdensome. And then we also added this other component, which is very controversial, which we call the Oklahoma option, which is the concept is derived from our experience in Texas as non-subscribers. But what we did is we said, listen, employers can choose not to carry traditional workers' comp coverage, and they can participate in this option, be a qualified employer, but they have to maintain a certain minimum level of benefits in these plans, and that those benefits have to mirror that in the administrative portion, the typical workers' comp portion of the bill. And then there's also some other belts and suspenders and accountability and everything. And we also included exclusive remedy, though, which is much different than what as I explained, works in Texas. This bill has premiums are down over the past 2 years, down 30% for a lot of employers. So it's working. It's also highly litigated. There's current, I think, around 18 lawsuits, either at the Supreme Court or been assigned to a Court of Appeals in Tulsa or Oklahoma City, either challenging the constitutionality of the Administrative Act, the option, or challenging just individual provisions within this. There's one particular lawyer out of Oklahoma City who really kept the prior system in place. So every few years, the legislature would look at workers' comp and say, well, we did reform 2 years ago, why are we still 48 in the country? and they kind of look around and be like, well, I guess we need to do another reform. And so they would do their reform. The problem is that the fox was guarding the hen house. And the main person who was responsible on a lot of these committees for drafting the language, working on the reform, working with the House and the Senate, was very invested in the current system and had a vested interest to keep it in place. And he did a fantastic job of that. And so we'd have reform after reform after reform, and nothing would ever change. And after it was a 2011 reform, we got a little tired of it, and we kind of spoke up. We said, listen, the reason nothing is changing is because the same guy who wants the system to stay in place is the one drafting these reforms, and has somehow convinced the powers that be, the governor, the House, the Senate, that this is the way to go. And so we were actually able to successfully jettison him from the process and run it without lawyers, excluding myself, but I don't really count myself as a lawyer being in-house counsel, at least on that front. And so we were able to reform workers' comp, and it's been very successful. But this guy has been challenging it every step of the way, and so there was initially off the bat a challenge to the entire bill, which failed, and then there was a challenge to the entire option component, which failed, and now they're just attacking one provision or another. But it's pretty interesting because he'll get a district court judge to kind of do his bidding on a case and come out with I would classify as an absurd ruling, and then he'll go to the paper and he'll come out with all this hyperbole, how I've just undone workers' comp, this is what happens when you have bad law, and now the state of Oklahoma is in chaos, and it's not. There was a case last year that he did this with where under the definition of compensability with respect to work-related injury, you have this concept of foreseeability. And basically the concept is, within the world of workers' comp, is that, listen, you can't go intentionally hurt yourself so you can get workers' comp benefits. And you can't just say, I'm tired of working, but I want to get paid something, I can't just have a paycheck, and so I'm just going to take this hammer and smash my thumb and get workers' comp. Okay, so you can't intentionally hurt yourself. And that's a concept. Makes sense, right? I mean, no big deal. It's not the same foreseeability you see within tort law, all right? And so he went and had this, in Florida last year, a district court judge in Dade County threw out their workers' comp law, said the benefits have been eroded to such a point that there's no longer a bargain for exchange between the employer and employee, and so exclusive remedy's dead, and so it goes free for all. Go sue wherever you want, whoever you want. And so that's caught a lot of attention, and so a lot of plaintiffs' bar here in Oklahoma have been looking at that and said, I wonder if we can do the same thing here, and they've been attempting to do so. Oklahoma Constitution has this odd provision, Article 2, Section 6, and it says that courts of justice will be open at all times to provide remedy to injured employees, something like that, I'm paraphrasing. And what they've done is they've taken this provision and they've turned it into what they call every wrong deserves a remedy. And so anytime you're injured, there should be a remedy for that. Which sounds, at first blush, right? Yeah, if you get injured, there should be a remedy. But what they've done is said, okay, well, if you get hurt in a work-related accident and the workers' comp statute, let's say, does not provide coverage for that. Let's say, for instance, you're high on the job and you get hurt because you're high, and that's the approximate cause of your injury. They're arguing, well, since the workers' comp statute does not cover that, since it excludes that, and you don't have a remedy on workers' comp, you have to have a remedy somewhere, so you have a remedy in district court under civil law. And so they've really run with this, and they got a judge out of Potawatomi County, I always mispronounce that, actually said that because a injury cannot be foreseeable and be compensable under workers' comp, I don't think this injury was. I think it was foreseeable. This guy could get hurt. I mean, it was just an accident, totally normal accident, nothing intentional about it. Covered injury. He was provided benefits under workers' comp. Everything's clean. And the judge said, no, but it provides foreseeability. This was a foreseeable accident, and so you can sue in district court. And so the lawyer immediately comes out, makes press releases, goes to the newspapers, I've undone workers' comp, there's no exclusion, all this stuff. And so we're dealing with a lot of that mess. which takes up a lot of time. And it's a little bit frustrating that that's how our courts are being, that's how they're spending their time these days, and the Supreme Court having to deal with this. And, it's frustrating. And I think it's gone beyond the world of seeking justice and a little bit more into just personal issues as far as I'm concerned. So, workers' comp, huge deal in our world, very expensive, very expensive. So that reform in 2013 was a big part of still remains a big part of my world, because now we're having to defend that each session and make sure that we have a law that's constitutional, can withstand scrutiny, and everything else. On the upstream side, so lease termination, that's a fairly common risk you deal with. We don't have a lot of lease termination issues. Landowners have become increasingly more sophisticated with respect to bargaining their oil and gas leases. I would say probably starting around between 2002, 2004, really with the shale boom, particularly in the Barnett area, and we used to have companies like Chesapeake coming in and just leasing up massive amounts of land. Really, throughout the past 12 years or so, you've seen an increased awareness by both landowners and lawyers that represent landowners as far as these oil and gas leases, and so they become much more sophisticated as far as how they negotiate. So the days of just walking up to a landowner, handing them a producer's 88 lease and say, please sign here with my 10-year term and everything else, those days really are kind of over. And so I wouldn't say that is prohibitive from getting oil and gas leases, but you do find yourself negotiating much more of them, which is completely fine. There's nothing wrong about that. It's the landowner's minerals, and they have every right to either lease them or not lease them, negotiate them however they want. But you're seeing them be much more sophisticated. So no, not as much 10-year terms, a lot of 3-year terms, which is a problem, because if you don't drill on the lease within the 3 years, the lease expires. So you have to start to commence operations before the end of the primary term to get into the secondary term. And so what you have is you get a situation where you have a drilling schedule and you have things lined up for the wells you're going to drill for a year, and you have to make sure you keep those leases alive and you can hold them by production. And so if you have a bunch of leases in critical areas that have short lease terms, then you have to make sure that you're able to drill those things up, hold them until you can come back and do them again. And then even sometimes you'll get lawsuits for failures to develop every now and again, where you didn't develop the formation like they wanted you to, so they're not getting the royalties and everything. And so there's oftentimes a rub between a company's drilling program and what the landowner, again, depending on the level of sophistication of the landowner, whether they have lawyers or not, there's oftentimes a rub between those two entities. And so that's occasionally an issue. We don't see it a lot, though. It's mainly more of an entry as far as, okay, how are we going to handle our drilling program? How do we make sure we don't lose leases? It also affects the marketability of leases, obviously. I mean, if you have a lease that's going to expire in 1 year, it's going to be much less marketable if you're trying to divest of that lease than if you have like a 10-year term, because nobody's going to buy a lease that's about to expire. But the thing that we are seeing that's a huge problem right now for us, and a lot of oil and gas companies, and if you follow oil and gas law at all in Oklahoma, you know this is a huge issue. It's a class action lawsuits. And so what we've seen a lot over the last, I would say, they've been really prevalent for probably the past 8 to 10 years, is you'll have a class action lawsuit on behalf of a nationwide class of royalty owners against the company and all their Oklahoma wells, for instance. And this isn't just Oklahoma, it's in Texas, it's in Kansas, it's everywhere. And the cause of action basically is underpayment of royalties. So when Oklahoma is a marketable product state. You have two different types of states. You have a marketable product states and you have at-the-well states that determine the basis for royalty payments. And a at-the-well state, which Texas is, for instance, the producer's obligation is to get the mineral out of the ground, and that's it. And it can pay the royalty off that value at that point in time. So if the producer then has to incur costs in order to transport the gas to a pipeline, to dehydrate the gas, to get it in a condition where it can go into a pipeline, all those costs, it can then deduct the royalty owner's proportionate share of those costs from the royalty payment. Oklahoma, on the other hand, is a marketable product state. There's an implied duty on the behalf of the operator, the producer, to put the gas in a marketable product. And so if you have to incur costs for transportation, for compression, for dehydration, whatever the case may be, if you have to incur those costs in order to get the gas to a point of sale, then you cannot pass those on to the royalty owner. You have to bear those yourself. Well, that sounds very black and white, and as stated, it is. It's very, very different reality. Oklahoma has a tortured case law history on the deductibility of what is called post-production costs, which those things are I'm describing: compression, dehydration, transportation, all those things. And so cases have been up to the Supreme Court several times on whether you can deduct and when you can deduct and all those things. And so what in Oklahoma, there's probably 2, maybe 3 firms that file virtually every one of these class action lawsuits. They go in, they'll file it. Every county in Oklahoma, nationwide royalty owners that they own, doesn't matter where you are, if you have a royalty interest, Oklahoma well, that you're the owner of, then it's part of the lawsuit. Well, as you can imagine, companies like Unit, and even more so companies, larger companies like a Devon or a Chesapeake or Newfield or whoever, when you think about a class action lawsuit versus every royalty owner, well, these are thousands and thousands and thousands of class members. And you get into really hundreds of millions of dollars of exposure. The lawyers know this, and they also know that they're very likely to get these classes certified at the district court level. Oklahoma traditionally, and I don't say this coming from any type of a political standpoint or whatever, this is just history of Oklahoma, matter of fact. But Oklahoma traditionally has been a populous state. And the district courts, especially in rural areas, remain so for the most part. That is still their mindset, very populous mindset. And so they're very, very quick to certify these classes. Once you get certified, now you're in trouble, because the lawyers know that you cannot afford to fight it. And you definitely cannot afford to come out on a losing end if you do fight it. And so you really have one shot, and it's at the Court of Appeals, to get the certification reversed. If you don't get it reversed at the Court of Appeals, you're in a lot of trouble, and you're going to have to settle, and they know it. Chesapeake just settled one a couple months ago for over $100 million. On a case they actually had pretty good facts on, too. I'm a little frustrated by that. And so this is a huge issue for us. So we got sued in Latimer County, southeastern Oklahoma, not a friendly county to a business of any kind. We got sued by the school district down there, Nola School District, because that's a very good named plaintiff, right? If you're going to sue in district court, be the school district. Very sympathetic. And so we got sued for one of these class actions. The judge certified the class and signed the opinion, literally, and they wouldn't dispute this if they were written by the lawyers on the other side. We appealed it. The Court of Appeals reversed it. They then, and this was in 2008, they then, and this was probably maybe 2013, they then refiled. They took the Court of Appeals decision, they looked at it, and they looked at, well, what can we remove from this to make our class certifiable? And so they amended their class, and they sued us again. And so now we began the whole process all over again. We had a class hearing, the second certification hearing in December, and now are awaiting ruling, which I don't anticipate to come anytime soon. I suspect the judge is trying to probably wait us out and hope that we settle, which is fairly unlikely, although we have dwindled their class down to 3 counties from the, I don't know, how many counties are in Oklahoma, 88 or 90? 77, okay. So we've gone from 77 counties to 3 counties, so it's a pretty good job on our part, I would say. And so you got to feel pretty good about that, even if it does get certified. Until in, I guess it was July, we got sued with another underpayment of royalties class action lawsuit. This time I think it was Ellis County. And so we get to do the whole thing a second time around. We removed it to federal court because in 2010, Congress passed the Class Action Fairness Act. They realized that this was a legit problem for businesses. You're getting held hostage in a lot of cases. And so they provided a mechanism where you could remove a class action lawsuit from district court, from state court to federal court, outside of your typical federal requirements with respect to diversity, amount of controversy, all of that stuff. The big one being diversity. Obviously, amount of controversy doesn't matter at all. But they provided diversity rules that made it easier to get into federal court. And so we did successfully get that, and we drew a really poor judge who certified every class action on the underpayment royalties that has come before him. We caught a break, though, because he's also a royalty owner. And so he's conflicted out. And so they had to reassign the judge. And so they assigned it to another one who happens to be a little bit worse than him and is also. So a lot of times justice is a flip of the coin. You get one justice, you're out of a lawsuit in 3 months. You get another, 5 years later, you're still working it. And so that's the way law works sometimes. And most of you guys probably know that and experience that on a daily basis, just like I do. And so we filed a motion to dismiss on the grounds of issue preclusion. But listen, this was certified, the Court of Appeals reversed, this has been litigated. These same parties, all these unnamed parties in this new lawsuit, they were unnamed parties in the one that got certified and overturned. And so you can't have your 2 bites of the apple. That was dismissed without hearing upon a amended petition where no leave for amend was filed. They just amended it and sent it in, removing the 3 counties that are currently at issue in our other class action lawsuit. So the judge immediately dismissed it without any type of hearing. We filed another motion to dismiss on the new petition. It doesn't take much to figure out that those 3 counties that are now at issue were not the sole counties at issue when this thing first got certified and overturned. It was every county. And so the lay of the land has not changed at all in our opinion. We'll lose again. But we'll keep filing false motions. And we'll make it life as difficult as we can. It's a tough deal. It's a very tough deal. It's frankly very frustrating. Because, let me be honest, the royalty owners don't really win in that deal. There's a lot of times in our justice system where the only winners are the lawyers. Class action lawsuits, bankruptcies, 2 situations where that's the case. It can be frustrating. I don't really feel like personally that the lawyers should ever be the ones that are the mutually exclusive winners and losers in a lawsuit. But in our world, that's the way it works sometimes. So, upstream litigation. Those are some of the obstacles we face there. Regulatory environment. Becoming very, very difficult. No surprise. Especially being a publicly traded oil and gas company. Not a great. You have a target in your back in today's current government. And that's no. That doesn't come from any place of animosity or anything else. That's just the lay of the land we're in now. Publicly traded companies are becoming increasingly more regulated. When you had the Enron, the WorldComs, everything in 2000 and 2001, the result was Sarbanes-Oxley, and then after the financial crisis, the response really went into steroids, and you had Dodd-Frank, which is now consistently rolling itself out and proving to be very, very difficult to manage. And so regulatory situation is very, very difficult. Everything from SEC, DOL, everything in between, very, very, very difficult, very cumbersome. So on the DOL front, Title VII is a big issue. We have to deal with quite a few discrimination or harassment lawsuits. We've actually over the last several years, had to deal with probably 4 or 5 actually male-on-male sexual harassment lawsuits from drilling rigs, which I never thought I'd ever see. But we actually had several of those. That was pretty interesting. Those went past, most of these, the EEOC doesn't do anything with it. They issue the right to sue letter, and then the charging party has 180 days from the issuance of that letter to find a lawyer to file a lawsuit against you in federal court. And so EEOC, for the most part, and with an exception in our experience I'll get to in a second, they typically don't find anything that's worth their time. And they're really looking for specific things and specific type of egregious activity that's going to trigger something that's on their agenda that they really want to pursue. But yeah, so we actually had a few male-on-male, and when those in the lawsuit were actually pretty interesting with respect to depositions and everything else. And I won't get into the different topics that got involved. But let's just say if you're going to fake a male-on-male sexual harassment claim in order to get some money, your deposition is going to be difficult. And it's going to be embarrassing for you. But this is a general part of dealing, just any corporation, 50 more employees, you're going to have to deal with EEOC, you're going to have to deal with discrimination claims, unfortunately, and a lot of it's just going to be, if somebody is upset when they get let go or something, a lot of times now, again, we live in a more litigious society, they're likely to file some type of claim against you. Now, that is certainly not to say that all these claims are frivolous at all. I've invested, I can't even investigate it, I can't even tell you how many claims over the years, and yeah, there's a lot of times they're legitimate and you have to address it and fix it, and it makes you sick, that type of stuff goes on. There's a lot of times people trying to get something for free. And so, like a lot of things in life, it varies. We in 2000 and, it's probably 12 now, the EEOC actually did bring a lawsuit against us. So this is very rare, it's a big deal, for failing to hire a woman to work on a drilling rig. As you might suspect, that's not a popular job for women. And it's a male-dominated job, and it's very, physically, it's extremely intense. It's very, very difficult work. There's a lot of men who can't do it. And so it's hard. And so it's not that we don't hire women, but women don't apply for that job. We had an instance that came up, and it started out as an individual charge. Husband and wife walked down to a rig, and they applied for a job. We had one position. And so the rig manager said, you tell me who wants to take it, and I'll hire that person. They said, well, give it to my husband. And so the husband took it. The woman, I think, went to work for another company, and husband ultimately got fired, and the wife filed a charge against us for failing to hire for discrimination. We actually had, in our position statement, we actually had a very poor job in the position statement, and we had a couple of statements in there to caught the EEOC's eye, and it ended up, they ended up suing us. So they went through the conciliation phase, which consisted of the EEOC telling us, the EEOC is required to try to conciliate. If they find wrongdoing, they're required by law to go to the company and try to conciliate that, get some type of resolution to it without first suing, and they don't like to do that, as it turns out. And in fact, the Supreme Court in mock mining this past session came out and said there was a split. A lot of companies had challenged whether the EEOC was actually doing this, and they were winning at the Court of Appeals level. And then there was one circuit that split it off. I can't believe it was either 6 or 7. I can't remember. They split off and said no. There's no judicial review over the EEOC's obligation to conciliate. And then so it went to the Supreme Court at that point, so you have a split among circuits, and the Supreme Court said, yes, there is judicial review. They do have an obligation to conciliate. There is judicial review. They do have to meet certain requirements on that, but they're very, very, very liberal with respect to their overview of that. And so, I mean, really just any like half good faith effort by the EEOC is probably going to meet the burden they have to meet now to get past that phase. But their conciliation with us was pay us $2 million, and actually, what they've done, they went out and they found 4 other women to be in this lawsuit. And so you have a total of 5 now. And they said, you owe us $2 million. We said, well, we're not going to pay you $2 million. And so we ended up going to court over it. And interesting, just how these things develop. The government, under any administration, the government's difficult. So we deposed these women, and 4 of the 5 women, the one original charging party being an exception, claimed that they testified under oath that they did not believe that they had been discriminated against until the EEOC actually called them and told them that. So this is the world we're living in. You fight this. So the pains of being, in-house counsel and dealing with stuff like that. We, $400,000 in legal fees later, we settle on the eve of trial, and now we explicitly say in our policies that we will consider women for drilling rig positions. So that's on the Title VII front. FLSA is really a big issue right now. The DOL is pushing it big time. You probably saw it came out in response to President Obama's directive in 2014 on classification of employees. They came out just a month, maybe so ago, and raised the limit on exemptions. So you have 3 exemptions on overtime: administrative, professional, and executive. And there's salary limits that are associated with those. So you can't take somebody who makes $10,000 a year and call them and make them fit an administrative exception. So about double those and up into $50,000 a year. And so that's going to catch a whole lot of people. So a lot of companies are scrambling, trying to go back and look at how they've classified employees that make from what was $23,000, that's now been bumped up to $50,000, that range, and make sure that everybody's properly classified, because those lawsuits are incredibly expensive because they're systemic, right? They go across generally speaking, across your entire company. We had an FLSA lawsuit several years ago for failure to pay for safety meetings that occurred 15 minutes before the actual shift started. And it's expensive because it's every employee, every safety meeting, every rig, every day. So those are very, very difficult. DOL is pushing FLSA claims really, really hard, so be really careful with those. OSHA is a big deal. So we're a drilling company, so OSHA inspects our rigs. They cite us. They've really beefed up their program a lot. And so with respect to what's an intentional, now there's criminal punishment now for employees of the company, including executives, if you have a willful violation on a recurring basis, you can go to jail for it. And so it's pretty scary for a drilling company when you have, when prices normalize, we'll have 80 rigs or so running. So that's 80 basically places of business operating on their own that the OSHA can go out and find something wrong. And you end up with repeats and then willfuls, and then you're looking at criminal, and it's a scary world. And then on the securities front, you guys probably know the story there. Just regulation after regulation. It's becoming a lot to keep up with. The latest is the clawback rule that's from Dodd-Frank, and this was proposed July 1st. I think the comment period ended September 14th. And so under SOX, you had a clawback rule that came out, but it was only for CEO and CFO, and it required intentional misconduct. Now it's every Section 16 officer, and it's on a no-fault basis. Okay, this is scary for a lot of reasons. One, Section 16 officers can cover a lot of people, not just your CEO and your CFO and your principal accountant, but like in our case, it covers our general counsel. And so if we have a restatement, a material restatement, without any fault, completely unintentional, they can come into our general counsel, who has nothing to do with the numbers at all. And they can now claw back on that 3 years any type of incentive, excess incentive compensation he received based on those metrics as they were reported. Okay, so very, very scary. And I'm not sure what the incentive there is when you go after people that have no involvement in financial reporting as far as the accounting aspect of it. I'm not really sure how that incentivizes better behavior, but this has really created quite a lot of ways, because this is the first time you're seeing on a no-fault basis people outside the guys that are in charge of the financials. Now you can get hit and you can claw back, and it's up to 3 years. Under SOX is just 1. So this was a very, very big jump for the SEC, and so they've instructed all the stock exchanges to implement these rules. You cannot be indemnified for it under your bylaws. You pay it back. And so, I think a lot of times in society we think of like a Lloyd Blankfein or Jamie Dimon, and you have to pay back $10 million of your $30 million package or whatever. I'm so sorry. Well, that's not the norm. Those are exceptions to the rule. And you have a Section 16 officer, and for a small publicly traded company that makes, I don't know, high 6 figures, and there's a clawback on $500,000 at point. I mean, it's a big deal. It's a serious concern, and so that's something we're watching very closely. Obviously, the final rules have not come out yet. I suspect they'll be very, very similar to the proposed rules, because that's what you see a lot of now. Administrative agencies aren't very flexible these days, and so you're really seeing a departure from the general corporate governance standard that we've always had in America, where there's trust put in board of directors. You're really departing from that, and now you're starting to see the government getting heavily involved in running of businesses. And that's a little scary. You have Stay on Pay now. Now it's required that you submit your compensation package to the shareholders for a vote. It's not binding. Okay, but you probably see a lot of stuff in the news about during proxy season, annual meeting time, with shareholders that are voting no on compensation packages, and that puts a lot of pressure on an organization. You have to respond to that. And then also the other recent thing that came out is CEO pay ratio. That's not as big of a risk or anything. It doesn't really. It's just an huge administrative burden and cost to the company, where you have to determine the median employee's total income, and you create a ratio versus the CEO's total income, where the CEO's total income is the numerator, the median employee income is the denominator. And that's actually an actual person, an actual employee that exists that represents the median. And you can keep that for 3 years. So I suspect that's providing some pretty good job security for whoever the lucky person is that happens to be that median employee, just so you don't have to go back and figure it all out again every single year. So you probably have a 3-year safe harbor where you can, be a lackluster employee or do anything to you. So it's a combination of, you have some things that are actual legitimate risk, and you have some things that are just really bureaucratic and really time exhausting and just really frustrating to deal with. And then you have the area of access to capital, which is really big right now. And so anytime you go into the bond market or credit market, you're going to have covenants in your either credit agreement or your indenture document. And you have to pay very, very close attention to those, because they're very, very restrictive on what you can do. We went to the bond market in 2011, and this was our first time in the bond market. And going through the indenture, and first off making sense of it and connecting, it's like an Alice in Wonderland type experience, where you're trying to connect all these different pieces to it. It's very, very difficult to read, but they're very, very restrictive, and you can look back and say, so we're constantly checking our indenture to make sure that we're not busting it by stuff that we do. And so that's a big area of risk we deal with. We've got about 10 minutes left. I've talked a lot. I don't know if any of it have any interest to any of y'all, so I thought I'd just open up the rest of the time to questions. You guys have any questions about what I do or our business or anything? Yes, ma'am.
When you were talking about landowners, I think you were mostly talking about the people who own the mineral rights. Correct. Kind of rearing up on you. Are you having anything? I know the surface owners who don't have the rights, they don't have a lot of recourse in a lot of ways. Are you having them rear up on you and in a bigger way than they have in the past?
Actually a little bit, and there's not a large enough sampling for me to say it's a trend, or if it's just kind of a blip. But yes, we do, whether they're the lessor, or whether they have acquired the land where the minerals have already been severed, yeah, you'll see people that they don't like drilling rigs on their property. And so, back in the day, there's actually kind of a cordial relationship between a lessor and a lessee. The lessor's, making money off of it. And so it's kind of a symbiotic relationship. That's kind of changed a little bit. It's much more adversarial, I think, than it used to be. And so, yeah, we do deal with stuff. And matter of fact, Devin just got hit with a big nuisance claim lawsuit for drilling activity on the landowner's property. So, yeah, I think you're seeing more of that. Yes, ma'am. Any other questions? Yes, sir?
Do you deal with any intellectual property rights, like protecting your logo or?
Yeah, very, very little, thank goodness. So we introduced about 2 years ago a new drilling rig that we created. It's proprietary, called the BOSS drilling rig, and it's an acronym for box on box self-stacking. Without getting into technical details and boring you with all that, the real innovation of the rig is its ability to rig up and rig down much faster and move to the next wellbore from a single pad, which is what every operator wants now. They want you to be able to rig up, rig down, get those times down, and they want you to be able to move to multiple wellbores very easily from a single well pad. And so we filed a patent on that design, and that's it turns out, a very long process. So we filed a provisional just to give us a year to make sure that we were okay with what we had submitted. There's no design changes, anything like that. And then provisional ran out last year, and so we filed for our permanent patent, and I'm told that it's 2-3 years before you hear anything, and probably pretty good chance it won't get patented, is what I was told. So we deal very little. That's actually our only involvement in the IP world, and so we stay out of it for the most part. Yes, sir.
Yes, I've never thought about this before. What type of like pre-inspection rights do royalty owners have with respect to your expenses? And I'm just thinking of we've had clients, tax clients where they've been getting large refunds on the royalties, but I think it's due to I think miscalculation of severance taxes. Yeah. I think perhaps under the old regiment, the 1% where we had a lower rate for horizontal and deep well drilling, and they've been getting these large refunds. I was just going to say, right. what type of rights do royalty owners have with respect to inspection of expenses and things like that?
Nothing express. They would have to call the company and say, listen, I want an explanation for what these charges are. So it used to be, before these post-production costs, underpayment royalties lawsuits became such a big deal, it used to be you just get the royalty check and there was no detail, right? It was just whatever the amount was that you were owed. That has since changed, and now companies are providing detail. If there are deductions, they're telling you exactly what deductions are, because they know there's a likelihood they're going to have to be able to defend those deductions. And so there's no express rights that they have where they can come in and audit or anything like that. But the more sophisticated landowners, royalty owners, they'll call, they'll ask, we'll explain to them what the situation is, where the gas is being sold, what type of charges we incurred, and so the Supreme Court came out with a case several years ago called Middlestat, which set up a test for whether you could deduct post-production costs, basically whether gas is marketable, which is the huge issue in all these lawsuits. When's gas marketable? The claims lawyers say it's never marketable until it's the main transmission line. So nothing you can ever do. Our position is, listen, we can sell this gas wherever we want. Wherever we first sell it on a arm's length purchase, that's when the gas becomes marketable. But they created a standard that says, well, if it's reasonable and it's proportionate and it's necessary to enhance the value of an already marketable product, then you can make the deduction. And so that's really the big case that everybody argues over now, because that is a very fact-intensive individual inquiry. And so our argument in these class action lawsuits is that, listen, court, you can't certify this class because every single royalty owner, we have to do the exact same analysis. And their counter argument is, it doesn't matter what the law says, that the fact of the matter is that gas is never marketable till it hits the interstate transmission line, and so everything before that cannot be deducted, and all those royalty owners fall in that category, and so you got to certify the class. So that's the argument. Theirs is very much based off theory. Our argument is really based on the law. So I like to think. Any other questions? Yes, sir.
Is there any potential relief from the Dodd-Frank regulations, or if they've got a life of their own and that's just
Kind of a life of their own. I mean, theoretically, you get if you had a Republican president, and you still control the House and the Senate, yeah, they could repeal some of that stuff and then do it.
Okay.
But I mean, getting 3 of 3 as everybody, that's tough. It's rare. You don't have it very often. I mean, Republicans had it for a while, didn't do a whole lot with it. The Democrats had it for a while, they didn't do a whole lot with it, and it's it's revolving doors. So it's tough to get all 3 at the same time. That's what it would take, to be honest. As long as you have a Democratic president or a Democratic-controlled Congress, you'll never see anything happen. It's set, it's done, it's moving on. Same with Obamacare, that's the same situation. It's down the tracks, and so it's going to take the trifecta for anything to change on those, I think. Anybody else? Okay, well, thank you guys so much. I really appreciate your time.